aspirations. In the past, he has acted as the Additional Advocate General for the erstwhile state of Jammu and Kashmir. Gaurav is also a door tenant at Fountain Court Chambers, London. He writes extensively on legal topics and is a keen political observer. Thank you, Gaurav, for doing this.
Thank you very much. It's a pleasure.
Just to inform all our attendees, after the discussion amongst the panelists, there'll be live questions to the panelists, and some questions put in by the attendees in the Zoom chat will also be taken up by the moderator. And without any further delay, I'll hand it over to Gaurav to start the session. Thank you.
Thank you very much, Pallavi. Thanks a lot. Good evening to you all, and good afternoon to Lord Goldsmith, who's very kindly joined us from his current residence in France. Just to introduce the broad discussion points for us today, the starting point of our discussion has to be a comment or a statement that Lord Bingham echoed in Bob versus Manning, that the conduct of government affairs by the Prime Minister and the Cabinet, collectively responsible to Parliament, lies at the heart of Westminster democracy. But this does not end here. Judges in the Westminster democracy system have a power of judicial review. Last year, the UK Supreme Court struck down a recommendation of the Prime Minister in the case of Miller versus the Prime Minister, a recommendation of the Prime Minister to the Sovereign asking that the Parliament be prorogued. The UK Supreme Court held that the recommendation was without justification and prevented Parliament from discharging its legitimate constitutional functions. There are several instances in India, for example, the Constitution 99th Amendment Act that amended the Constitution to create a National Judicial Appointment Commission for greater participation of government and Parliament in appointment of judges to constitutional courts, was struck down by the Supreme Court of India in 2015 on the grounds that the National Judicial Appointment Commission violated the basic structure of our Constitution. The principles of constitutionality based upon which legislations as well as governmental action is tested are ever evolving in their nature. Some of them are well settled, but some of them continue to change according to the context and the situations in which they are invoked. And the result of that often is the widening of scope of judicial intervention in the function of both government and Parliament. What are the concerns that arise out of that situation? Sirvai, one of the great constitutional lawyers of our country, while speaking at the Chimanlal Sitalwad Memorial Lecture regarding the rule of judiciary under our constitution, expressed a view. I mean, he said that power is not property. Power under our constitution is but the means to an end, and the end is greater public good. Therefore, power must be exercised by whichever limb, either of the three limbs of government that is best suited to exercise that in a particular situation. So there are persuasive arguments for greater judicial intervention to fill the interstices of governance that otherwise compromise public interest in certain situations. But there are counter-arguments and equally persuasive counter-arguments against excessive judicial intervention, and somewhat sort of a different term that is used called judicial activism. For example, in the 2019 Reith Lectures, Lord Sumption expressed a view that the demands for judge-made law, which require judges to express a view on matters that are ordinarily a part of collective moral judgment and regulate personal choices, adversely impact the ability of the judges to then enforce protection of personal rights, and this is a casualty of the rule of law. This happens sometimes just because of limited capacity, and matters relating to personal rights just getting deprioritized in the queue. Some would argue that the public interest litigation jurisprudence in India has had that effect. These are competing views on which I would welcome and now sort of request the panelists to express their views one by one. But I wanted to say that the purpose of this debate is not to profess, to suggest any right answers by the end of this debate. The purpose is really to begin asking the right questions. My first question is directed to Lord Goldsmith. And I wanted to start with a topic that is of much interest in India regarding appointments to the higher judiciary. And what I wanted to ask him was two things. Why was the Supreme Court established to replace the judicial functions of the House of Lords in England? And how are judges now appointed as of today in the English legal system to higher courts, and particularly the Supreme Court?
Well, thank you, Gaurav, for that question. Can I say, first of all, I'm delighted to be on this seminar. I'm delighted to be speaking with my two very distinguished co-panelists. This is the closest I can get to India at the moment, of course, because of COVID-19. It's not quite the same, and I'm very much looking forward to coming when it becomes possible to travel again. But I'm going to do the best I can to feel that I'm in India at the moment. And I want to thank Bar and Bench too for hosting this and for the introduction that we had. So a lot has changed in the United Kingdom in recent years. You picked up, Gaurav, on two questions, and they really start with the question of why we now have a Supreme Court rather than what used to be the House of Lords, strictly speaking, the Judicial Committee of the House of Lords, because it was actually a committee of the legislative chamber, though the judges actually played no part in the legislative procedures while they were actually sitting judges. So this was formed as part of the Constitutional Reform Act of 2005, which was a major measure introduced by the Labour Party, which was in power at the time, really to create new powers and new procedures in a number of areas. The Labour Party removed a lot of the hereditary peers from the House of Lords. It decentralised government by passing a lot of powers to devolved administrations in Northern Ireland, Scotland, and a little bit even to Wales, and created the new Supreme Court. Now, in one sense, the Supreme Court was only a change of address. The House of Lords moved from sitting as a committee of the House of Lords in the Palace of Westminster to going all the way across the road to what used to be the the Middlesex Assizes. But it's turned out to be a lot more than that. The judges remained the same, with only a little exception. The people who appointed as judges remained the same. The powers absolutely remained the same. The right to go to the Supreme Court was exactly the same as it was to the House of Lords. But notwithstanding that, it has been quite a major change. And that isn't because the hierarchy and the anatomy and the architecture of the change was in fact to create more interventionist courts, but that seems to have been what happened. I think we'll come back to that when we discuss some of the important constitutional cases that we've seen in recent years. But let me just answer your question about appointment. Of course, the judges who were appointed to the Supreme Court, to the House of Lords, were very senior practitioners, almost always coming from the Court of Appeal. They were appointed by the Lord Chancellor, a government minister, but also a judge himself. It therefore looked as if they were appointments of government. Actually, they weren't particularly, and nobody has ever actually pointed to any bias shown by the previous members of the House of Lords sitting as judges in relation to cases. But the appearance certainly looked as if they were not independent of government. So that's the critical change. There are rules now about appointments of the top judges, the judges for the Apex Court. They're appointed on merit. People have to be people of good character. Neither of those propositions, I hope, are surprising. They do include a requirement now to encourage diversity in the range of persons available for judicial selection, which is significant. We now have the occasional, we do have some women judges. No one from any other minorities at the moment. The procedure is governed by the Constitutional Reform Act, and it involves a new commission, an appointments commission, which selects the practitioners according to the sort of rules I've identified from candidates who satisfy certain basic conditions. There are consultations that take place. The recommendation is then made to the Lord Chancellor, who still then has to make the appointment through Her Majesty. So what will happen is there'll be some further consultations. There's a very limited power really to make the Commission think again, not to substitute names, but to make them think again. It's happened once or twice, and then the names go forward to the Prime Minister, who in turn sends them through to Her Majesty the Queen, and she makes the formal appointment. So that's essentially, it is different from the previous system, with limited exceptions, though the same people, I believe, have been appointed who would have been appointed before. We do now have one judge, Lord Burrows, who's purely an academic, and that's, I think, is a good thing. But he's the first of those directly appointed to the Supreme Court. Lady Hale, who was the previous president, had been an academic, but she'd also served, as it were, as a regular judge after a period of time as an academic. So that's it in a nutshell, and I hope that answers the questions that you put to me.
It does very much. Thank you very much, Lord Goldsmith. My next question is to sort of put broadly the same question or a similar topic to Mr. Datar, because the issue of appointment of judges by the collegium in India has come under severe criticism over the last few years. Unlike a judicial appointments commission in the UK, in India it's basically the judiciary that self-appoints and has primacy, at least in the appointments of judges in most cases. And I wanted to ask Mr. Datar what his views were on that, and whether he, and particularly the sort of decision of the Supreme Court to strike down the amendment regarding the creation of National Judicial Appointment Commission. Sir, I think your mic is muted.
Yeah, sorry. Thank you, Gaurav. And before I continue, I must thank Lex Witness and Bar and Bench for being the sponsors of this program. And Gaurav, thanks to you for taking all the trouble of putting it together and putting up with the three of us and our delays and so on and so forth. But it's been wonderful. Thank you, Lord Goldsmith, for being here. And thank you, Pratap, for also joining this program. It's a delight to be